Please subscribe, like and share this content. It means a lot to us. Thank you in advance. Cornell Law School. Repealer of U.C.C. Article 6. Bulk transfers and revised U.C.C. Article 6. Bulk sales. Part 1. Subject matter and definitions. Paragraph 6(106). Schedule of distribution. 1. The seller and buyer shall agree on how the net contract price is to be distributed and set forth their agreement in a written schedule of distribution. 2. The schedule of distribution may provide for distribution to any person at any time, including distribution of the entire net contract price to the seller. 3. The buyer's undertakings in the schedule of distribution run only to the seller. However, the buyer who fails to distribute the net contract price in accordance with the buyer's undertakings in the schedule of distribution is liable to a creditor only as provided in Section 6(107). 1. 4. If the buyer undertakes in the schedule of distribution to distribute any part of the net contract price to a person other than the seller, and, after the buyer has given notice in accordance with Section 6(105), some or all of the anticipated net contract price is or becomes unavailable for distribution as a consequence of the buyer's or seller's having complied with an order of court, legal process, statute, or rule of law, the buyer is excused from any obligation arising under this article or under any contract with the seller to distribute the net contract price in accordance with the buyer's undertakings in the schedule if the buyer, A, distributes the net contract price remaining available in accordance with any priorities for payment stated in the schedule of distribution and, to the extent that the price is insufficient to pay all the debts having a given priority, distributes the price pro rata among those debts shown in the schedule as having the same priority. B. Distributes the net contract price remaining available in accordance with an order of court. C. Commences a proceeding for interpleader in a court of competent jurisdiction and is discharged from the proceeding. Or, D. Reaches a new agreement with the seller for the distribution of the net contract price remaining available, sets forth the new agreement in an amended schedule of distribution, gives notice of the amended schedule, and distributes the net contract price remaining available in accordance with the buyer's undertakings in the amended schedule. 5. The notice under subsection 4(d) must identify the buyer and the seller, state the filing number, if any, of the original notice, set forth the amended schedule, and be given in accordance with subsection 1 or 2 of Section 6(105), whichever is applicable, at least 14 days before the buyer distributes any part of the net contract price remaining available. 6. If the seller undertakes in the schedule of distribution to distribute any part of the net contract price, and, after the buyer has given notice in accordance with Section 6(105), some or all of the anticipated net contract price is or becomes unavailable for distribution as a consequence of the buyer's or seller's having complied with an order of court, legal process, statute, or rule of law, the seller and any person in control of the seller are excused from any obligation arising under this article or under any agreement with the buyer to distribute the net contract price in accordance with the seller's undertakings in the schedule if the seller, A, distributes the net contract price remaining available in accordance with any priorities for payment stated in the schedule of distribution and, to the extent that the price is insufficient to pay all the debts having a given priority, distributes the price pro rata among those debts shown in the schedule as having the same priority. B. Distributes the net contract price remaining available in accordance with an order of court. C. Commences a proceeding for interpleader in a court of competent jurisdiction and is discharged from the proceeding. Or, D. Prepares a written amended schedule of distribution of the net contract price remaining available for distribution, gives notice of the amended schedule, and distributes the net contract price remaining available in accordance with the amended schedule. 7. The notice under subsection 6(d) must identify the buyer and the seller, state the filing number, if any, of the original notice, set forth the amended schedule, and be given in accordance with subsection 1 or 2 of Section 6(105), whichever is applicable, at least 14 days before the seller distributes any part of the net contract price remaining available. Paragraph 6107. Liability for non-compliance. 1. Except as provided in subsection 3, and subject to the limitation in subsection 4, a buyer who fails to comply with the requirements of section 6104, 1e, with respect to a creditor is liable to the creditor for damages in the amount of the claim, reduced by any amount that the creditor would not have realized if the buyer had complied, and b. A buyer who fails to comply with the requirements of any other subsection of section 6104 with respect to a claimant is liable to the claimant for damages in the amount of the claim, reduced by any amount that the claimant would not have realized if the buyer had complied. 2. In an action under subsection 1, the creditor has the burden of establishing the validity and amount of the claim, and the buyer has the burden of establishing the amount that the creditor would not have realized if the buyer had complied. 3. A buyer who, a. made a good faith and commercially reasonable effort to comply with the requirements of section 6104, 1, or to exclude the sale from the application of this article under section 6103, 3, or b. on or after the date of the bulk sale agreement, but before the date of the bulk sale, held a good faith and commercially reasonable belief that this article does not apply to the particular sale, is not liable to creditors for failure to comply with the requirements of section 6104. The buyer has the burden of establishing the good faith and commercial reasonableness of the effort or belief. 4. In a single bulk sale, the cumulative liability of the buyer for failure to comply with the requirements of section 6104, 1, may not exceed an amount equal to, a. if the assets consist only of inventory and equipment, twice the net contract price, less the amount of any part of the net contract price paid to or applied for the benefit of the seller or a creditor, or b. if the assets include property other than inventory and equipment, twice the net value of the inventory and equipment less the amount of the portion of any part of the net contract price paid to or applied for the benefit of the seller or a creditor which is applicable to the inventory and equipment. 5. For the purposes of subsection 4b, the net value of an asset is the value of the asset less, i. the amount of any proceeds of the sale of an asset, to the extent the proceeds are applied in partial or total satisfaction of a debt secured by the asset, and 2. the amount of any debt to the extent it is secured by a security interest or lien that is enforceable against the asset before and after it has been sold to a buyer. If a debt is secured by an asset and other property of the seller, the amount of the debt secured by a security interest or lien that is enforceable against the asset is determined by multiplying the debt by a fraction, the numerator of which is the value of the asset on the date of the bulk sale, and the denominator of which is the value of all property securing the debt on the date of the bulk sale. The portion of a part of the net contract price paid to or applied for the benefit of the seller or a creditor that is applicable to the inventory and equipment is the portion that bears the same ratio to that part of the net contract price as the net value of the inventory and equipment bears to the net value of all of the assets. 6. A payment made by the buyer to a person to whom the buyer is, or believes he, or she is, liable under subsection 1 reduces pro tanto the buyer's cumulative liability under subsection 4. 7. No action may be brought under subsection 1b by or on behalf of a claimant whose claim is unliquidated or contingent. 8. A buyer's failure to comply with the requirements of section 6104, 1, does not, I, impair the buyer's rights and or title to the assets, 2, render the sale ineffective, void, or voidable, 3, entitle a creditor to more than a single satisfaction of his, or her, claim, or, IV, create liability other than as provided in this article. 9. Payment of the buyer's liability under subsection 1 discharges pro tanto the seller's debt to the creditor. 10. Unless otherwise agreed, the buyer has an immediate right of reimbursement from the seller for any amount paid to a creditor in partial or total satisfaction of the buyer's liability under subsection 1. 11. If the seller is an organization, a person who is in direct or indirect control of the seller, and who knowingly, intentionally, and without legal justification fails, or causes the seller to fail, to distribute the net contract price in accordance with the schedule of distribution is liable to any creditor to whom the seller undertook to make payment under the schedule for damages caused by the failure. Paragraph 6-108. Bulk sales by auction. Bulk sales conducted by Liquidator. 1. Section 6-104, 6-105, 6-106, and 6-107 apply to a bulk sale by auction and a bulk sale conducted by a liquidator on the seller's behalf with the following modifications. A. Buyer refers to auctioneer or liquidator, as the case may be. B. Net contract price refers to net proceeds of the auction or net proceeds of the sale, as the case may be. C. The written notice required under Section 6-105, 3 must be accompanied by a copy of the schedule of distribution, Section 6-106, 1, and state at least, I, that the seller and the auctioneer or liquidator have entered into an agreement for auction or liquidation services that may constitute an agreement to make a bulk sale under the laws of the state of. 2. The date of the agreement. 3. The date on or after which the auction began or will begin, or the date on or after which the liquidator began or will begin to sell assets on the seller's behalf. IV. The date on or after which more than 10% of the net proceeds of the sale were or will be paid, if the date is not stated in the schedule of distribution. V. The name and mailing address of the seller. Vi. Any other business name and address listed by the seller pursuant to Section 6-104, 1a. Va. The name of the auctioneer or liquidator and an address of the auctioneer or liquidator from which information concerning the sale can be obtained. Vi. A statement indicating the type of assets or describing the assets item by item. X. The manner in which the auctioneer or liquidator will make available the list of claimants, Section 6-104, 1f, if applicable, and X. If the sale is in total or partial satisfaction of an antecedent debt owed by the seller, the amount of the debt to be satisfied in the name of the person to whom it is owed. And D. In a single bulk sale, the cumulative liability of the auctioneer or liquidator for failure to comply with the requirements of this section may not exceed the amount of the net proceeds of the sale allocable to inventory and equipment sold less the amount of the portion of any part of the net proceeds paid to or applied for the benefit of a creditor which is allocable to the inventory and equipment. 2. A payment made by the auctioneer or liquidator to a person to whom the auctioneer or liquidator is, or believes he or she is, liable under this section reduces pro tanto the auctioneer's or liquidator's cumulative liability under subsection 1d. 3. A form substantially as follows is sufficient to comply with subsection 1c. Paragraph 6-109. What constitutes filing? Duties of filing officer. Information from filing officer. 1. Presentation of a notice or list of claimants for filing and tender of the filing fee or acceptance of the notice or list by the filing officer constitutes filing under this article. 2. The filing officer shall a. Mark each notice or list with a file number and with the date and hour of filing. B. Hold the notice or list or a copy for public inspection. C. Index the notice or list according to each name given for the seller and for the buyer. And D. Note in the index the file number and the addresses of the seller and buyer given in the notice or list. 3. If the person filing a notice or list furnishes the filing officer with a copy, the filing officer upon request shall note upon the copy the file number and date and hour of the filing of the original and send or deliver the copy to the person. 4. The fee for filing and indexing and for stamping a copy furnished by the person filing to show the date and place of filing is $1 or for the first page and $1 for each additional page. The fee for indexing each name more than 2 is $1. 5. Upon request of any person, the filing officer shall issue a certificate showing whether any notice or list with respect to a particular seller or buyer is on file on the date and hour stated in the certificate. If a notice or list is on file, the certificate must give the date and hour of filing of each notice or list and the name and address of each seller, buyer, auctioneer, or liquidator. The fee for the certificate is $1 or if the request for the certificate is in the standard form prescribed by the Secretary of State and otherwise is $1 or, upon request of any person, the filing officer shall furnish a copy of any filed notice or list for a fee of $6. The filing officer shall keep each notice or list for 2 years after it is filed. Paragraph 6-110. Limitation of actions. 1. Except as provided in subsection 2, an action under this article against a buyer, auctioneer, or liquidator must be commenced within 1 year after the date of the bulk sale. 2. If the buyer, auctioneer, or liquidator conceals the fact that the sale has occurred, the limitation is told and an action under this article may be commenced within the earlier of 1 year after the person bringing the action discovers that the sale has occurred or 2. 1 year after the person bringing the action should have discovered that the sale has occurred, but no later than 2 years after the date of the bulk sale. Complete non-compliance with the requirements of this article does not of itself constitute concealment. 3. An action under Section 6-107(11) must be commenced within 1 year after the alleged violation occurs.